a certain branch of the Muslim community. And one of the parties appointed as their representative on the panel someone who was not Muslim. And then this gave rise to a dispute. And it was held by the United Kingdom Supreme Court that there is no violation of discrimination law if the arbitrator is selected by reference to nationality and or religious allegiance. The parties have a golden opportunity in their arbitration clause to agree to regulate by consent how the arbitration will be conducted. But this is an opportunity that most parties neglect to focus upon. And so the reality, in England at any rate, is that very often it is the arbitrator or the arbitrators who seem to have control over the nature of the procedure that's actually applied. But I feel that commercial advisors, legal advisors, are missing a trick here in not focusing upon this question of the way in which the arbitration will actually be structured. The arbitration agreement under the English legislation has to be in writing. Of course, that can be emails and the like, electronic. The English legislation recognises the principle of, it's a horrible word, but I suppose I'm going to have to say it, separability. This is the concept with which I'm sure you are familiar, which is the notion that even if there's a question whether the main contract is in fact a nullity, the arbitration clause which is contained in the main transaction is regarded as separable, hence this horrible word separability, is independent. The child is already independent of the mother, as it were, and therefore this gives the arbitration tribunal its jurisdiction to investigate the substantive question whether the main transaction is indeed valid or invalid. And of course that interlinks with the competence principle, which is that the arbitration panel has, at any rate, first shot at the question whether indeed it is authorized under the arbitration clause to investigate the relevant dispute. Now, ladies and gentlemen, we now come to a hot topic. All of this is hot, but this one is red hot. And tentatively, I approach this red, super red hot, white hot actually, topic, which is the English, I should say common law, form of judicial support of the arbitration process. Remember the double helix? The support of the arbitration process. When one party says, I thought we had an agreement that we would go to arbitration. Why are you suing me in the civil courts of Sicily? Which is in Italy. Which is a wonderful place to eat. And to drink. But not to litigate. And my good Italian friends confirm. First two things, great. Third thing, forget it. Now, we know that these wicked people who, not the Italians, the wicked person who wants not to go to arbitration finds a jurisdiction which is not conspicuous for its speed, and commences some sort of negative declaration, some juristic device, in order to torpedo, that is the metaphor, isn't it, to torpedo the arbitration process. And the English, and they have been doing this, the English, for a couple of 100 years. It's not a recent invention. They say, yes, but you agreed to arbitrate. This, in England, is regarded as a contract. If you have failed to arbitrate, then you have breached your contract. If you have breached your contract, there shall be applied to you the remedies for breach of contract. One of the remedies is damages. Damages is useless in this context because the computation of loss is too vague. Instead, the remedy that is obviously available and appropriate is an injunction, which was mentioned this morning. An injunction to stop the defendant from continuing to litigate in wherever it is. Let's listen briefly, ladies and gentlemen, to Lord Hobhouse in the House of Lords in 2001 in Turner and Grovitt on the subject of anti-suit injunctions. Anti-suit injunctions. He said, certain preconceptions and misunderstandings still tend to persist as to the nature of this type of restraining order. This type of restraining order is commonly referred to as an anti-suit injunction. This terminology is misleading, since it creates the impression that the order is addressed to and intended to bind another court. None of this is correct. When an English court makes such an order, it is making an order which is addressed only to a party which is before it. The order is not directed against the foreign court. The order binds only that party in personam and is effective only insofar as that party is subject to the jurisdiction of the English courts. There can be no clearer definition of the anti-suit injunction, no clearer demolition of the fallacy that this is somehow a direct interference with the sovereign jurisdiction of the foreign court. Ladies and gentlemen, if you hear that, it's hogwash. Forget it. The relevant person is misrepresenting the nature of the anti-suit injunction, which is in personam and is a reflection of that civil law wrong committed by the defendant in failing to honour the arbitration agreement. So the anti-suit injunction is available in most civilized parts of the world, available to regulate litigation in most civilized parts of the world, if the English court has jurisdiction and recognises that the relevant defendant is in breach of the arbitration clause. If that party has, in breach of the arbitration clause, commenced litigation in New York, or in Tokyo, or in Sydney, or in Rio, or in Moscow, that person will be subject to an anti-suit injunction. If, this is an exciting topic, if that person has commenced litigation in breach of the arbitration clause in an uncivilized part of the world, and I refer to the European Union,